God save the United States of America, the state of Florida, and this honorable court. Please be seated.
All right, good morning, and welcome to a session of oral arguments at the 5th District Court of Appeal. We only have two cases scheduled today, both civil cases. Each side will have 20 minutes for their oral argument. If you need time, as far as for rebuttal, appellant's counsel, let me know how much time you want. If you have a cell phone or other electronic device, make sure you turn it off and put it in the silent mode so the arguments are not interrupted. Also want to take a moment to introduce the other members of the panel. Seated to my right and your left is Judge Jay Cohen, and to my left and your right, Judge Jamie Grosshans. All right, we'll proceed on the first case, Orange County versus Ferguson.
Good timing. Good morning, Your Honors, and may it please the Court.
Would anyone like us to start all over?
All right. May it please the Court. My name is Derek Angel. I represent Orange County and its trial counsel, Dennis O'Connor, in this appeal. I would like to reserve 3 minutes for rebuttal, please. This order, following a defense verdict and a 6-day jury trial, does three things. It grants a new trial based on Mr. O'Connor's alleged improper conduct during the case. It directs a verdict in the presumptive second trial on all issues except for the amount of plaintiff's alleged damages, and it sanctions Mr. O'Connor personally for his conduct. And we believe that all three of those legal effects require independent reversal. And I'll start with
Well, let's start with Mr. O'Connor's putting in front of the jury a document that reflected that the plaintiff was there for stealing.
and that was the guilt.
And would you, do you think that was proper?
No, it was not proper. We conceded that in our brief.
So if it's not proper, it's improper.
Correct.
So why shouldn't he be sanctioned for that?
Well, the impropriety by itself is not the end of the analysis. It's the first step of the analysis. And sanctioning a lawyer has to, first of all, has to be after causing a material effect that impacts the proceeding. In other words, we would have to find that that impropriety caused the mistrial. Well, there was not a mistrial here, there was a new trial, which means that they would have had to follow through with the Murphy test, because without the motion for mistrial contemporaneous to that impropriety, there must be fundamental error.
Well, you could impose sanctions even if you didn't grant a new trial, right?
I don't think so. In fact, that's what we learned from the Tenev case, which
You could find the attorney in contempt of court, right, for violating the order in limine?
that would be one remedy, but there's no contempt finding here, and these due process standards that follow with a contempt finding were not followed, of course. So there was no contempt here. Under Moakley, they could sanction Mr. O'Connor if he caused the wrongful incurrence of attorney's fees, which is what they're attempting to do in this motion. But that's not what happened here, because in order to have properly caused a new trial, then we would have to follow through with Murphy. So I don't think an impropriety by itself can substantiate an order of sanctions, unless, of course, it causes a mistrial. But there was no motion for mistrial. There was no objection to placing that in front of the jurors.
Well, if sanctions were reversed, could the judge go back and hold a contempt hearing, followed all the procedural requirements?
I don't know that with a remand for contempt, I mean, contempt is not an issue in this case. I mean, we did not had a motion for contempt. We had no warning.
Right, but you're asking for an opinion that says no new trial and no sanctions. The trial judge still has jurisdiction afterwards to decide other matters, like your offer of judgment, for instance.
Sure.
If the finding of misconduct was supported by the record, but the particular sanction imposed was not, why would the judge be precluded from imposing a different sanction?
Well, a contempt here, again, which is not part of this order, but a contempt hearing, how would the plaintiff be the one entitled to fees for a contempt hearing? Criminal contempt, for example.
Well, I understand that. I'm not saying that you know, if we say that's an improper sanction, but there was misconduct, I'm asking you, what do we do as far as an opinion?
Well, if we look at Murphy and we look at Moakley, the concurring opinions in those decisions, there's plenty of ways to deal with attorney misconduct other than a new trial. In fact, Murphy, the harmfulness discussion in that case talks about it's sort of an invitation for judges both at the trial and appellate level to punish a lawyer with a new trial. And Murphy says we should not be doing that. We need to focus on the fairness of the proceedings as to the litigants. And so there's all sorts of other ways to punish misconduct, which is what I think you're getting at, Judge Vander, which is...
But saying that letting the jury know that the person was there for stealing when the court has prohibited that from coming out, does that suggest the trial was less than fair?
Well, whether or not it was fair or not, that's, again, not the whole question. The question is whether it was harmful and incurable, that's all, of course, Murphy, and then so damaging the fairness of the trial that our public loses its faith in the system. That's what happens when we don't have an objection, which is what we had here.
Let me ask you this. How about the comment, I believe it was at the end of defense counsel's closing, about the Army will take care of them?
Well, again...
Was that a violation of the order in limine?
I do not believe was improper. First of all...
What's the purpose of that comment, other than to suggest that if there's, psychological issues and that will require counseling or medical treatment, that the Army would take care of it, that the Army would pay for it?
So
how is that not a violation of the court's order in limine?
Two answers. First of all, there's no objection again, so we're under Murphy. I don't see how we're not.
Okay, but my question was, is it a violation of the order in limine?
And my answer to that is no. And to understand the context, you have to look at the exchange with the plaintiff when that was going on in the evidence. On direct, Mr. Panagakis asked his client if he had gotten any counseling with the Army. And Mr. Ferguson says, no, they won't cover it. The insurance won't cover it because this incident was pre-military. On cross, Mr. O'Connor asked him about that counseling. There's an objection, there's a sidebar, when the objection was overruled. And the judge recognizes that it's not about who's going to pay for counseling, which is what the order in limine and TRICARE refers to. Instead, he said it's not the payment, it's the availability. And the fact that Mr. Ferguson had counseling available for free at
His statement was, this young man doesn't need therapy. He doesn't need anything. He's doing great. And if he does, which would seem to refer to the therapy, then the Army will take care of its own. How can that be related to anything other than damages?
Because in that question, and again, the context was that he had...
Not the context of the testimony. The statement in closing, this young man doesn't need therapy. If he does, then the Army will take care of its own.
So the first half of that statement, that he doesn't need therapy, was obviously hotly contested through this case, whether he needs any counseling at all.
So he's saying he doesn't need therapy, we win.
Correct.
But if he does need therapy, then the Army will take care of its own. How is that anything but an invitation, anything other than inviting the jury to find that even if he does have a permanent injury, the Army will take care of him?
Because the evidence was that...
I'm not talking about the evidence. I'm talking about what was argued to the jury during closing argument.
Because the evidence was that he had availability for free counseling in the military. Not that they would pay for private counseling, which is what the whole discussion was during the back and forth with the plaintiff during the evidence. He said, I want private counseling.
The plaintiff's claim was that because of the county's negligence, he suffered PTSD, which would require therapy. The argument Mr. O'Connor made was, in essence, that last sentence, even if he needs therapy, the Army will take care of it.
And I think I'm beating a dead horse.
I mean, is that a reference to a collateral source or not?
I don't think so, because a collateral source has to do with who's going to pay for damages. And this was not about payment or collateral sources of an insurance company or TRICARE. This was...
It's payment of who's going to provide the treatment.
Providing free treatment, I think, is different than who's paying for private treatment, which is what they were asking for, and it's very clear that that was the context. And again, that evidence, when it came out, They made this objection, and it was overruled. The judge overruled it because, again, it was the availability, not the payment, that was the subject of the discussion.
Let me ask you one other thing. You mentioned in your brief about comparative negligence.
Yes, Your Honor.
Are you suggesting that the plaintiff having a pink mohawk hairdo is comparatively negligent?
I think it's more than just that. I think that the pink mohawk, the gauge earrings, and the fact that, in his words, he showed his ass,
That happened after the incident, right?
that's actually not quite clear. I know they said that in their answer brief.
Right.
If you look at the...
So how does having a pink mohawk or having earrings, how does that constitute comparative negligence?
Because negligence is just the failure to be reasonable under the circumstances, right? That's what negligence is. It changes depending on whatever we face ourselves with. Here we have an individual who went into a jail dressed in a way that might...
He asked for it. Is that what you're saying?
I'm not saying he asked for it. I'm just saying that a jury could...
That's what it sounds like you're saying.
I'm not saying he asked to be attacked if we agree attack occurred, which I think there's plenty of questions of fact as to that.
He somehow was negligent and brought this on himself, and therefore there's comparative negligence.
I think...
That's what you're saying.
Well, I think with the attitude where he said it caused me to be targeted, then how does that not a causal... The way he acted caused him to be targeted. That was his own testimony, that my attitude caused my targeting.
You know, it sounds like the same logic of a woman who's sexually assaulted who is wearing a miniskirt.
I have to respectfully disagree with that characterization, Your Honor. I don't think that...
How's it, I mean, he alleged he was sexually assaulted by an inmate, and you're saying, well, in part because look what how he dressed and what he was wearing.
What do you
And the
look
fact
like?
that he showed his ass, as he said, but it caused the targeting. And I don't know how that's the same thing as... I appreciate that.
Having pink hair and an earring isn't showing your ass.
But he did say his attitude was.
Well, that's not what the argument that was made. The argument was about his pink hair and the earring. That's what's of particular concern.
Well, I appreciate the comparison. I just think that in a jail, you're dealing with inmates, criminals. I think there's a different level of decorum in that context. And I think a jury could find that.
Really, so if it was a group of young girls who went through the jail program and one of them dressed in a miniskirt, then that's the argument you'd be making?
I don't know that I'd be making that argument in that context. And again...
Same argument, though.
I appreciate the question. I do think it's a little bit different. But in any event, this all presupposes that an attack occurred. And that speaks to the directed verdict nature of this, which we all know the standard, and we've all read hundreds, if not thousands, of directed verdict cases. You draw the inferences in favor of the non-moving party, and if there's any question of fact, then it's for the jury. And Mr. Ferguson's story had so many inconsistencies. He reported different things to different people. The circumstantial evidence was replete that nothing of the sort happened, or it was so exaggerated that it might as well have been a fabricated incident, that of course this goes to a jury. I don't understand where we must accept as a matter of law that this occurred, or that the county was, as a matter of law, breaching any duty. In fact, there's a colloquy between Mr. Panagakis and the court where they both say that violating internal protocol, of course, is not negligence. It's evidence of negligence. And yet that is exactly what this order says. It says that based on the county's internal investigation, there's no question of fact, as a matter of law, this is negligence. I don't understand how that survives review on the directed verdict in particular. So returning to the new trial and the court-ordered tours issue, my reading of this record, and I acknowledged that it was improper of Mr. O'Connor to use that phrase after he'd been told a handful of times not to. But
Certainly
again,
would make that seem intentional then, wouldn't it?
it would seem to be, but not necessarily. Now, I do think that I think indicates the due process issue with the post-trial hearing. That hearing was not noticed as an evidentiary hearing, and that motion was...
That issue was such a bone of contention throughout this case that it's inconceivable how that would be viewed as accidental.
Well, I can understand it's one reading of this, but again, there's no evidence there was no finding that Mr. O'Connor did not testify. There was no appropriate credibility determinations. He did not have the opportunity to present Ms.
But
Latham.
it wasn't even as if he just put the report up there. He highlighted that section of it.
Well, that's a different issue, the report, and I'm not so sure that is what happened. That's actually very unclear. As many times as I read through this record and looked at the various documents, exactly what was highlighted or not highlighted, that is not clear on this record. Well, the only evidence we have of that is what we have from Ms. Latham's affidavit that said the document was up there for less than 10 seconds and that Mr. O'Connor was directing the jury to a different aspect of it. That's the only evidence that we have. Everything else is unclear. So, and that's different than using the phrase court-ordered tours. And Your Honor's right, it was a bone of contention. But if it's so substantial, where's the objection in the closing argument? When he mentions twice within about 5 seconds of each other, on this court-ordered tour, this is what happened. Where is the objection? How is this not a Murphy case? And how is this not a Companioni case? Which is, my reading of that is, and this is black letter from a unanimous Supreme Court in a civil case, which we hardly ever see, of course, that if there is attorney misconduct, there is a black letter requirement to move for mistrial.
If assuming the trial judge applied the wrong standard, what's your best argument on why we should go ahead and just say reinstate the jury verdict versus remand for the trial court to apply the correct standard?
Well, we look at the little case from the First District, I think last year, where if the trial judge fails to apply Murphy when it should, and that's what this case is, I don't see how it isn't, then the court can go ahead and apply that standard here instead of a remand. And that, again, the First District just did that in remarkably similar circumstances. And I think this court has done that recently as 2017 with the Walt Disney versus Grimes case. It was the same sort of thing. It was one of Mr. Nation's cases. He'll know a lot more than I will about that. But that was a new trial that Judge Myers granted based on attorney misconduct, but did not walk through Murphy. It was not preserved. In this case, this court, in relatively summary fashion, reversed for that reason. So I don't think there's any obligation, and I don't think the case law supports the necessity of a remand for the Murphy test to be applied in the first instance. But again, but here we have no argument that Murphy is satisfied. Their brief doesn't attempt to analyze Murphy. Mr. Nation knows that this case is not a fundamental error case. And if there is any fundamental error in this record, and to me the most troubling aspect of all of this was the judge attempting to tell the jurors that Mr. Ferguson was there as a volunteer. That's not an order in limine. That's changing the evidence. And if Mr. O'Connor hadn't resisted that, these jurors would have been told something that wasn't true and then found out from the evidence, because it was inevitable, the way the plaintiff put on their case, that this was a court-ordered tour after all. Not just from the pre-recorded videotape deposition of Officer Doremus, but Officer Jackson, who in their case said this was a court-ordered tour with some juveniles. And at that point, as this court explained just 5 years ago, well, 6 years ago now, and I think it's called hung tai win is how you say it, once that evidence is in the record, on cross-examination or what have you, as a lawyer you have the obligation to move for curative or to strike or mistrial, otherwise it becomes part of the evidence. And Mr. O'Connor was proper to speak to it at that point, and the judge was in error by preventing it. Now, does that mean it was proper for Mr. O'Connor to mention it? No, I've said that a few times. But he had a nice little appellate issue in a box with that, with the open door issue.
You have 3 minutes.
Oh, thank you, Your Honor. Okay. So I do think that when we look at that, the judge's desire to tell, as he used the phrase on 2 different days, a white lie and a little fudge, which I think all of us have to agree is not how jury trials should ever proceed, I think that does circumscribe the discretionary view that we take at when we usually look at a order granting new trial. So I will reserve my time, and I appreciate it.
Good morning. I'm going to start on Friday afternoon and dispense with any of the Murphy argument. The judge clears the courtroom.
You do acknowledge that the trial judge utilized the wrong standard?
I don't, only because of...
You don't think that... All right, go ahead.
Yeah, and I'll start it with this.
I'd love to hear your explanation of that.
On Friday afternoon, he clears the courtroom, and after a week of battling this court-ordered issue, from voir dire on, the next sentence.
The court-ordered part, you know, if that isn't, if you all hadn't opened the door for that, I don't know when the door is ever opened to such an issue. So I'm not terribly persuaded by that. The difference between court-ordered and then putting a document up that indicates stealing, I think, is a quantitative difference. But are you trying to suggest that the door wasn't opened to the admission of the fact that it was court-ordered?
The door was not open to the focus that was put on it. Once that document was up.
If it's opened, Mr. Nation, it's open. You know, once that's in evidence, it's in, and everybody can talk about it.
But the judge has the right to control the courtroom.
Yeah, but you'd agree that you
That's
can't
right.
sit there and say, plaintiff's counsel, you can refer to court-ordered tour, but defense counsel, you can't use the term court-ordered tour.
They can refer to it, but they cannot, under this court's ruling throughout the trial, continue to refocus on it. And what happened Friday afternoon is the judge said, if you do it again.
That's just.
But Mr. Nation, wasn't this the entire basis of your client's claim, that the reason the county was negligent was that they were operating under a policy that involved a court-ordered tour?
The document says there are lots of different tours. The same document. It was all, the one document was put on the Elmo. It has, I think, A through F, the different kinds of tours. They just walked through all of them. There were two sections, one of which the court ordered said you needed to have parents or guardians there, and then the next section said you had to have chaperones. That was the only purpose for putting that up, to say people on these tours, all of them, have to, if they're minors, have to have chaperones or their parents there.
Well,
That was the purpose of putting that up.
Numerous other times court-ordered was mentioned without objection.
Yeah, and I have a list of those. I wanted to start at the end where the judge says, if you do this again, not that I'm going to grant a mistrial, I will declare a mistrial. He said, I'm going to declare a mistrial if you do it again.
You know, going back to Judge Evander's observation, you simply, you know, you don't get to tell lawyers, well, this side can do it, but this side can't do it. And I think it's a fair reading of this record that the plaintiff had opened the door in terms of the court-ordered tour, and that's the way I think the jury would have understood it. And the court had a different standard for the plaintiff than he did for the defendant.
My reading of it is that the whole form went in to show you need chaperones, you need parents
I
there.
don't care why it went in. It showed what it showed.
But
and the
then-
evidence was what it was.
But then Mr. O'Connor kept saying, on this jail tour, that was court-ordered. He was told by the judge, right or wrong, told by the judge, don't do that again.
No, it's an attorney has to comply with the judge's order, and Mr. O'Connor didn't. Now, like Judge Cohen and Judge Grosshans, I question the correctness of the order on the opening the door as far as the court-ordered tour references. Now, the stealing, I think, is a whole different story, and it's hard to excuse that conduct. But regardless of whether your client opened the door or not, why doesn't Murphy apply as far as the standard on the motion for new trial?
So the purpose of unobjected to error is to make sure the trial court is alerted to the issue and is aware of the issue and can guard against it and make a ruling against it.
And can correct it.
And can correct it. And the judge...
If there's no objection, then, and there's no motion for a curative instruction, then the trial judge has no opportunity to cure any perceived error.
And that's where the judge's ruling or statements on this, you can look at the court ordered and stealing all as part of one plan. The object was to get in front of this jury that this was somebody who'd been charged with a crime, and that's why he was on the jail tour. It's all part and parcel. Whether the Gilstrap record, court ordered, the whole tone was, along with the defense of the hair and the earrings, he had this coming.
You're drawing some distinction on Murphy and what case law do you cite for there to be an exception to Murphy if the trial judge would have understood what you meant.
Well, in this case, the judge, in this case, the judge.
Because Murphy is a test that the trial judge applies after the trial is over.
Right. In this one, it was the same issue essentially throughout Friday, and I'm going to get to Monday. Friday, he's saying, don't talk about this again. Don't say it again. He says it twice. Then he puts up the Gilstrap record, at which there is an objection to that, immediate objection to the Gilstrap record. The judge said, I'm going to declare a mistrial. Here, he could have done it right then. The judge knew what was going on. The judge is put in the same, in this case, was put in the same position that counsel is under the Robinson v.
Did the
Ward.
judge declare a mistrial?
He did not.
Okay.
It was new trial.
So you can talk about it, but unless you do it.
Yeah, it was new trial and directed verdict is what he ended up
But
granting.
the fact is that a mistrial was never declared.
That is true.
And at that point, it seems to me that the analysis has to be under Murphy.
And doesn't Campione say that an objection's
didn't
not,
hear
doesn't Campione say that an objection's not enough? There has to be a motion for a mistrial, and if there's no motion for mistrial, then Murphy applies.
If it is a mistrial, in a situation where you have, it's unobjected to, in each one of these cases, like
Well, but
Grimes,
Campione, there was objection, but there was no motion for
there
mistrial.
was no motion for mistrial. I agree
Right,
with you.
and they said Murphy applies. So I have the same question for you that I had for opposing counsel. If the judge applied the wrong standard, and Murphy should have been applied and the trial judge did not apply it, what's your best argument that it should be a remand rather than a reinstatement of the verdict?
In this case, just because of the ongoing problems in front of this particular jury, and then we culminate with the document in closing. If this sanction, I'll go to the sanction, isn't withheld, is our system of justice going to be protected by this? Is it going to be protected with what happened in this particular case? If you're allowed to treat the judge's orders through this trial as was done here, and in the hearing on the sanctions, Mr. O'Connor said the document was inadvertent. The rest of this, I felt, was within my right to do. And I know I'm talking about the sanction now, but how can that, if it's intentional, you were asked if it was intentional. It was. By his own statements, it was intentional. And then the document is put up that's highlighted, but before it's put up, you're told, this is like a deathbed confession. And the part that is redacted is the part that is supposed to be kept out, which is all part of the defense, which is court-ordered stealing, had it coming. There's no evidence of any comparative fault. The only evidence is that they violated their own terms and that, or procedures, and that there was negligence on the part of Orange County. There's no other evidence in this case. They could only have been swayed by what happened through the jury.
Even if the evidence established negligence by the county and that evidence was undisputed and there's no comparative negligence, was there disputed evidence on causation?
No, I don't have it. There was none on whether or not this was a legal cause of injury. There was on damages, disputed on damages.
The defense expert said, this can go away in 3 months, and you all waived your claim for past medical damages. So, if you believe the defense expert, would that mean that there's no damages?
That's damages.
Other than what's waived?
That's damages. Legal cause, there's no dispute as to legal cause of injury. None at all. And so the only dispute would be the amount of damages. They can get up and argue.
Dispute as to whether there was injury at all.
No factual dispute. There's an argument about it, but there is no factual dispute about it. There's no evidence that disputes what happened to Mr. Ferguson.
Whether there was any damage as a result of whatever might have occurred.
There is. Yeah, then they can fight about that, the damages, of course. And there's no DV asked for on that, and so trial should be on that.
Well, not just damages, but injury, period.
But not legal cause of injury. That question 1 on the verdict form, no evidence supports their side on that. There was a motion for directed verdict. The renewed motion was brought after trial, and that renewed motion for directed verdict in accordance with the prior one was granted. And so there was no record evidence at all disputing injury and cause.
How do you support a judge's ruling, assuming that we believe that the door had been opened, how do you support a judge's ruling that allows one side to talk about it but not the other?
Both, they can put the evidence, in my mind it seems easy. It comes in, but you can't focus on that court-ordered one when the sole purpose of bringing that in is to say, look, juveniles either have to have a parent or chaperone. It goes to the issue of negligence. They have to have a chaperone or a parent or a guardian with them. That's the only reason that was put in front of them. And then, after being told you're not to mention court-ordered tours, it's highlighted in front of the jury on day one of the trial. It's highlighted. He's told not to do it. That day, does it again.
The county's violations were of what? What regulations were violated under the plaintiff's theory?
Their internal procedures saying got to have chaperones with them or guardian. I'm sorry?
Internal regulations as to court-ordered tours?
No, all tours. They have policies on the tours, and that was what that document was. The document was put up, I think I have a copy here. The document was put up, and it sets forth the county's regulations. That's in our record. And then Mr. O'Connor gets up and has the tech highlight court-ordered, and he's just focused on court-ordered. And the judge said, don't. The fact that that document is shown to the jury and it has A through H concerning who's going to be allowed in on jail tours doesn't tell the jury that this is a court-ordered tour, doesn't give any indication of that at all. Nor did Mr. Panagakis when he was going through it at trial. They simply then jumped on it saying, without permission, without telling the court, I'm going to focus on court-ordered tours, and started asking about court-ordered tours. I don't believe that opened the door as to that issue. They can talk about all of them, but the judge said, don't focus on that one. He has the ability and the right, being there, to control the way that evidence is coming in. And it's not that he gave one side the ability to do it and the other not. He gave them both the same exact right.
Let me ask you this, Mr. Nation. Mr. O'Connor's comment in closing the argument about this young man doesn't need therapy, and if he does, then the Army will take care of its own. How would you respond to your opposing counsel's argument that that was simply a comment, appropriate comment on the evidence?
It's not. It's talking solely about the cost in the future. That's all it can talk about is the cost in the future. The cost of that care, and the Army is going to take care of their own. And I think even hearing the argument, he had difficulty articulating it because he's saying, well, they're just talking about the Army, giving him treatment, that's it. No, it's the cost of that treatment in the future.
Well, there is no cost if it's done in the Army.
Which is why they were not allowed to bring that up. That's the basis of the motion in limine, to keep the collateral source out. Let me check.
It's not a collateral source. There's not a payment being made because there is no cost.
Well, I don't know. I send TRICARE requests for lien information on TRICARE all the time. If it's a result of a third party, they'll seek reimbursement. They do it day in and day out. Let me just check here.
And what did the order in limine say?
On that issue?
Yeah. Do you have the exact language?
I have it right here.
Okay.
Defendant is not to be permitted to mention, infer, or elicit testimony regarding the cost of future medical care services under the TRICARE rate of reimbursement and/or the availability of TRICARE benefits.
Well, isn't there subsequent language provided by the government?
I'm sorry?
Isn't there, does it go on and talk about services provided by the government? I think there's more than that in the order.
I can grab it right here. I don't have that in front of me.
Okay, we can find it. Thank you.
It'll certainly be around 133, 134 in the record.
Mr. Nation, what disturbs me, I think, the most about the closing argument was that your client didn't ask for, not only did not object or ask for a mistrial, but didn't ask for any type of curative instruction. And it seemed like both the briefness of the document being on displayed to the jury would have lended itself to a curative, or even just questions to see what they had seen on it. And then also this mention of the Army could potentially have been addressed with a curative instruction, but the trial judge was never given that opportunity. How would you address that?
The judge, having sat through the whole trial, I think looked at this cumulatively and decided this was the right remedy. It's the right remedy for Mr. Ferguson. It was the right remedy to protect the office of the judge and to protect his own authority in the courtroom. At that point, they'd been exposed to this so much, just bringing more attention to it would not have helped. You know, the case Ward v. Robinson, 2nd DCA, talks about the problem that trial counsel has put in with repeated violations of the court orders. In this case, because it was so often, and as was said, and Mr. O'Connor continued undeterred, it was so often that they put the judge in that exact same position that they were talking about in Ward v. Robinson. At that point, the judge had intervened, counsel had intervened time and time again, and the judge had already said, made his pronouncement.
And then this action by the judge, this alleviates the need to go through an entire Murphy analysis?
Absolutely, because Murphy, the whole purpose is to protect the judge so that the judge is aware of this in the system. The judge is able to protect the system. Here, the system had been attacked, broken during that time and at that time. All of this together says Murphy isn't the right test when the judge says, I'm going to declare a mistrial. And he says it twice and puts the document up in closing, all three of them. How does Murphy apply when the judge says, this is the sanction I'm going to award if you do it again?
It's like the judge saying, I'm going to hold you in contempt, but then never does it. I mean, I just don't see how that analysis relieves the court of the responsibility to apply the correct standard. I don't think that the Murphy standard is a judicial protection act. I think it really focuses upon the impact, the ability to cure an issue vis-a-vis the jury, not the judge, the jury.
And in this case, if that's the analysis the court does, I would submit this is the case where the Fifth says Murphy applies.
Right. And if Murphy applies, then?
It's a new trial.
Even though the trial judge didn't apply Murphy?
I think the court on this issue either remands for a Murphy analysis, but I think the record's clear of what the fundamental problems were with this trial. Nobody can look at this and say, Mr. Ferguson got a fair trial. Nobody. Anybody reading this would know he did not. And the court can apply that. I guess the other remedy is remand it, apply the Murphy analysis, and send it back up. Well, if that's the analysis.
Right.
Right. Thank you.
Thank you, Mr. Nation.
Thank you, Your Honors.
Yeah, Mr. Angel, from a policy point of view, you're understandably and appropriately arguing that, look, parties, you should preserve, you should preserve your record. You should give the judge an opportunity to give curative instructions, to grant mistrial, et cetera, et cetera. And there is a strong policy consideration to make parties preserve the record. But there's also a policy consideration that we should not reward attorneys for engaging in misconduct. And, you know, how do we balance those two here? Because it certainly appears to be some significant misconduct on at least two issues here.
Well, I think we...
And it's hard to determine, you know, how much effect that had on the jury. But on the other hand, we don't have a motion for mistrial.
Well, and I think we don't, like I started to say earlier, we look at the concurring opinions in Moakley, that there's lots of ways to deal with attorney misconduct. And if this was as egregious as the plaintiff's claiming it was, the judge is within his rights to refer Mr. O'Connor to the bar. I don't think that happened here, and there's no evidence it did. This court has done that plenty of times. We've read plenty of opinions with those sorts of things, and what those do to lawyers and professionally, personally, it cannot be understated. Some lawyers think nothing of it. Other times we see those referrals, and then you look 3 years later and there's a Florida bar opinion sanctioning the lawyer or disbarring or suspending. That's the vehicle for dealing with any perceived misconduct. Not granting a new trial, which ultimately punishes the litigants who, if on the cold review of a record, received a fair trial, which regardless of what the court said outside their presence, Judge Cohen, I think you've acknowledged that the door was open to court order tours. So even though Mr. O'Connor shouldn't have done that, that doesn't mean that it wasn't a fair trial nonetheless.
Well, Mr. Nation disputes the concept that the door was open, saying that it was only put up there in order to demonstrate the need for supervision or...
There is a distinction there, and I'm running out of time. So there's two types of tours, essentially. There's court-ordered tours, and there's everything else. And on court-ordered tours, they must be accompanied by their parent or legal guardian, minors. As to all other tours, whether they're on a field trip or what have you, it can be a chaperone. And that's significant here because the parents left at their behest and against jail policy, but the parents asked for it, so a jury could say that was reasonable of Ms. Hungerford. But they were still left with Officer Doremus, who I mentioned emphatically denied that there was anything that happened that day. If you read that testimony, that's not just, I don't remember anything, that's, no, I've never heard of anything like that happening. But that could have been considered a chaperone. So it did matter that he was on a court-ordered tour to substantiate their theory of the case. And so unless there's any further questions, I appreciate the court's time and consideration of this case, and we respectfully request that the jury verdict is reinstated and the sanctions are vacated.
All right, thank you both.